On December 14th, I went upstairs to the 4th floor of this building and picked up a document that looks similar to this. And that's a petition to run for school board in New Brunswick. We have a special election happening on Tuesday. It says that completed nominating petitions shall be filed with the county clerk on or before 4 p.m. on December 21st, 2012. The county's position, I found, is that the deadline was actually a different date. And so I wanted some clarity on when the county counsel's office became aware that the county clerk's office had been distributing this incorrect information, and what was done to remedy that when the office became aware of that.
I'll answer your question, Charlie. Obviously, you're directing it to me. I received a phone call from Anthony Vignola, the attorney, special counsel for the New Brunswick Board of Education, on Friday the 21st, who indicated to me that the deadline of the 21st was not accurate and was contrary to law. He cited case law to me, and he also cited the statutes. I reviewed that with him, and I agreed with him. Since the notice of the election was in the newspaper on December the 13th, the 10 days would have expired on Sunday, December the 23rd. Therefore, the next day would be, the next business day would be the date in which the 10 days would expire. Therefore, I contacted the county clerk, told her that the deadline needed to be the 24th, and that she then accepted that opinion from me, from my office, and petitions were accepted on the 24th. The interpretation that Mr. Vignola provided to me, I agreed with. I think it's clear under the statute that there needs to be a minimum 60-day notice for any type of election. I think it's clear under the statute that there needs to be a minimum 60-day notice for any type of election, in this case a special election for school board. The clear meaning of that statute is there's a 10-day window, 60-day minimum notice, 50 days before an election. The interpretation is logical as well because of the fact that the interpretation needs to give the greatest opportunity for the most people to be able to at least put their names on the ballot so that the people can decide who is going to be elected. And to interpret otherwise would to limit the number of people who would have a right to be voted upon, which from my experience with you, Charlie, that's the kind of thing that you would be supporting. So our interpretation was that those petitions were allowed to be accepted, and indeed they were.
I agree with what you said. My qualm is that no notice was given to anyone that the deadline had been changed. That's not right. It's not fair. Notice should have been given to the public that the deadline was incorrect and that it was being modified.
Well, again, it was Friday afternoon, the 21st. The deadline was extended to Monday. I can't answer the question as to what notice would go to who, whether that's the Board of Education or whatever. That's the answer.
My topic I wanted to speak about was the election that occurred. And I know at the prior meeting I had presented a document to the members of the board regarding a 60-day notice requirement for holding these types of elections. And I got an opinion from an attorney in town.
I think it's clear under the statute that there needs to be a minimum 60-day notice for any type of election, in this case a special election for school board.
Is that fair to say that's a correct or incorrect assessment?
I'm going to defer this to our attorney.
It was the opinion of the attorney that counseled us, in my opinion, that that's not an accurate statement.
Thank you. That attorney was County Counsel Tom Kelso. He said that to me at the Middlesex County Board of Chosen Freeholders, and I think his interpretation is correct. And I think that means we have a real problem because the election was held without proper notice.
But the election was fair. There were no unfair advantage. There were 6 candidates, and two prevailed. And it was done appropriately with both proper advertising, proper notice. So I respectfully disagree with your interpretation, and I would challenge Mr. Kelso to speak to me or Mr. Vignola or both of us.